Hello everyone, and welcome to our lecture recording on chapter 12 and on genuine consent. The lecture recording for today continues our analysis of the validity of contracts, which we have started with in chapter 11, and that's when we looked at the issue of capacity to enter into contract. Today we're going to look at the next step in this analytical structure. So we're going to assume that there are no issues with the question of capacity, so we move on to the next step. Now we say a contract may still fail because there's no real consent by the parties to the contract. So we remind ourselves that the basis of contract is agreement, because without an agreement there would be no contract, or what's referred to sometimes as consensus ad idem, so consensus of ideas or meeting of the minds. So if there are problems such as mistake or misrepresentation or duress or undue influence or unconscionable conduct, okay, then there is no genuine consent, which of course goes back to this idea of classification of contracts as to enforceability. Okay, so that takes us again back to what we discussed on page 195 in relation to classification of contracts in chapter 7. We said that contracts could also be classified in relation to their enforceability as valid, voidable, or void. And that's the same theme we're going to continue with for today. So our learning objectives are on page 294, and we'll start with the first learning objective, which asks us to identify and assess the effect of different mistakes on liability in contractual situations. Okay. Now, the general starting point is to say that if a mistake operates, okay, the contract is going to be rendered as void, and it's void ab initio, which means from the beginning. So nothing at all can be said to arise under the contract. It's void ab initio. So as it says here, it places parties in the same position as if no contract had been made. Okay. Now, if there's misrepresentation, which we will look at after we look at mistake, that only makes the contract voidable. We'll explain that in just a minute. So there is an important difference if third parties are involved in relation to misrepresentation. Now, at the bottom of page 295, it says the law is reluctant to accept mistake as a ground for avoiding a contract. Okay. So the law is reluctant to accept mistake as a ground for avoiding a contract because it would provide an easy way out for a dissatisfied party and would also seriously undermine the certainty and the liability essential to commercial transactions. So this should remind you of our earlier discussions of the characteristics of legal systems, and we said that we like to have certain characteristics inherent in our legal system, and one of them was this idea of certainty. So we go back to page 6 and we look at the characteristics of a legal system, and you'll find that they have to be we would like to have clarity and certainty in our legal system. Alright, let's then look at mistake, and we continue with this slide where it explains that because of the Australian commercial law, or the ACL, there are now fewer reports or fewer reported cases in relation to mistake. So this is now covered as well under the ACL in relation to misleading, for example, behavior under sections like section 4, 18, 29, or in relation to unconscionable conduct under sections 20 and 21. Now there's a note also that money paid under a mistake of law rather than mistake of fact, which means that the mistake was in relation to something, to the operation of the law or the law that applies, rather than, for example, a mistake of fact that relates to the matter that, for example, we are going to be buying and selling. Again, let's go to our example of selling a pen for $10. We both agreed that we want to buy and sell this pen, but it turns out in fact that this pen say doesn't exist. Okay, we both thought that it does, but it does not. So that of course is a mistake of fact. But there could also be mistakes of law, for example, whether we can actually sell this pen and buy it without having to pay tax on it, for example. Okay, that would be a mistake of law. But sometimes that money paid under a mistake of law may also be recoverable, and could be recoverable through something called restitution, the doctrine, the equitable doctrine of restitution. Okay, you can learn more about that as well if you go to page 414. So this is of course in chapter 16, but there we will talk more about these things in relation to remedies and also in relation to restitution. Alright, so let's go back to mistake of fact, and the discussion of course talks about that, your textbook talks about that on page 296. So it says that two principles here. First is that only mistakes of fact can render a contract void. Okay, but a mistake of law, for example, wrongly interpreting a statute, or a mistake of judgment, for example, buying clothes and then not liking the style or color, or a mistake as to quality, these then the party generally cannot rely on the mistake to avoid the contract. So mistakes in relation to law or judgment or quality are not going to get you out of the contract. Okay. However, it says money paid under a mistake of law may be recoverable if the money was paid by the party under a mistaken belief that they were under a legal obligation to pay it, or that the payee was legally entitled to payment of it. That's the first principle on page 296. The second is that there are very few mistakes of fact that prove grounds on which courts can invalidate a contract. So as a result, a plaintiff may prefer to bring an action under the ACL, for example under section 4, for misleading representations with respect to future matters, or under sections 20 and 21 in relation to unconscionable conduct, or even under section 29 for false or misleading representations. Alright. Let's then look at mistakes in relation to their types, and you have an in brief box on page 297 that gives you 4 types, well really 3 types of mistakes that we will look at today. So there's the common mistake, and this is an agreement. So there is an agreement, but there's a common error as to existence or identity of subject matter, and that makes it the contract, that is, makes the contract voidable at equity. Okay. The effect, however, is that the contract may be void at common law. Okay. But this of course requires the mistake, the common mistake, to be a fundamental type of mistake. The key point is that under common mistake there is still an agreement. Under common mistake there is still an agreement. Alright. So on page 297 it says again, in the case of a common mistake the parties acknowledge the existence of an agreement, but because of fundamental assumption as to the existence or identity of the subject matter, they wish the court to set the agreement aside from the beginning. In other words, the parties are asking the court to treat the agreement as having no legal effect. Now, the courts have generally been reluctant, as we said, to avoid contracts in which the common mistake involves accidental qualities or attributes of the subject matter. And you're given the examples on page 298. So it says a common mistake must involve the existence or identity of the contract's subject matter, and the failure of such contract to get off the ground is due not to the mistake, but to the absence of the thing on which the contract is based. So, for example, they give you the Pritchard case, where the beneficiary of a life insurance policy which had lapsed because of non-payment of premiums paid a renewal premium to revive the policy. However, neither party was aware that the insured had died prior to the payment being made. So, because of this common mistake about the existence of the person, the subject of the life insurance, and that they have died already, that changes the agreement into a common mistake, and then the transaction would be void ab initio. Okay, compare that though with McRae on page 299. So it says there, where the contract is for the sale of specific goods which have perished at the time the contract is made. The sale of goods legislation of the various states and territories provides that where there is a contract for the sale of specific goods and the goods without the knowledge of the seller have perished at the time when the contract was made, the contract is void. The contract again is void. For example, if A sells a car to B, and unknown to A, the car caught fire and was burnt out an hour before the sale, then the contract would be void and there would be no liabilities incurred on either side. However, if it's a mistake as to the quality of subject matter, for example as in McRae, the parties were in agreement but they were mistaken as to the existence of the subject matter. But the position is not so clear whether the subject matter has existed but changed. That is where there is a mistake as to the quality of the subject matter. And you are given the example there of the case of Bell on that point, and it continues with the mistaken equity, and the question there was, what is the effect of a finding of common mistaken equity rather than at common law? So here is then equity says may give relief where the mistake involves the quality or attribute of the subject matter. So even though you are not going to be able to get any relief from finding a mistake of quality, you might still in common law, you might still be able to find it in equity. Okay, so here the courts may treat the contract as voidable and order its rescission or annulment, but it's a discretionary remedy. So if it's a mistake, a common mistake, yes, but not a fundamental common mistake, it's a common mistake that goes to the quality, for example, of the subject matter, then there would be no remedy at common law. However, you can argue still in equity that you can get rescission in relation to a mistake in relation of equity, if you like, a mistake in relation to the quality of the subject matter. So if there's no relief at common law, you can try to argue it under equity, where in equity, if there's a mistake as to quality, you could still try to convince the court to treat the contract as voidable and order its rescission or annulment. But again, this is just discretionary. It's a discretionary remedy, not like or unlike common law, where it is a matter of right. If the court finds that there was a mistake, a common mistake that goes to the a fundamental, if you like, common mistake that goes to the existence or to the identity of the subject matter. Now on the right hand side of this slide you find that there are these other types of mistakes. So if we go back to page 297, you'll find that there's also mutual mistake and unilateral mistake and something called non est factum. A mutual mistake, again, is a mistake made by both parties concerning a material fact that's important to the subject matter of the contract against there is no genuine agreement. I will look at examples of mutual mistake rather than common mistake. Here again the contract is void, or you have unilateral mistake, so only one party is mistaken about a material fact regarding the subject matter of the contract, so again there's no genuine agreement and the contract may be void or voidable. Or there's the non est factum, which is mistake as to the nature of the agreement, which again it means that there's no genuine agreement, and again the contract would be void. So let's look at the remedies for a while. So on page 307 we start talking about remedies for mistakes. Okay, so at common law, okay, you can get a declaration that the contract is void ab initio if the mistake affects the very existence of the contract, which means of course that a party to the agreement is not bound by it and any money paid may be recovered by an action and decision, i.e. you rescind the contract. Okay, or you could have something in equity, which you could have rescission, making the contract voidable, or restitution or rectification if the terms of the contract have been incorrectly written down. And you could also have remedies under statute. So this is the ACL. You have misleading or deceptive conduct, or unconscionable conduct, or a false or misleading representation, and you can get your remedies under that, and we'll talk more about these remedies, especially the ACL, under chapter 16, which starts on page 411 rather, and it talks about the remedies in equity and at common law and under statute, and it talks about also the so we said it talks about equitable remedies, and it talks about the ACL. However, if you also would like to have a larger discussion on the remedies under the ACL, you can have a look at chapter 18, in particular the discussion starting from page 501. We're not going to discuss this in much detail in this course, and we're not going to cover that chapter in this course, but if you're interested in that, you can go on and have a look at it in chapter 18 starting from page 501. Alright, then let's go back to our discussion of mistake and look at common mistake. This is one mistake, so both parties are making the same mistake. So for example, I want to sell you a pen and you're going to pay me $10 for the pen, and we both think that this pen actually exists. In reality it does not. We're making the same mistake. You think it exists, I think it exists, we are both wrong. That's a common mistake. Okay, there's still an agreement, even though the agreement, of course, in this instance, because it goes to the existence of the subject matter, is not helpful because we will not be able to execute the contract. So you could see then that there are two types of this mistake, the common mistake. The left hand side talks about mistakes as to the existence of the subject matter, like the example I've just given you, or mistakes as to the quality of the subject matter. Okay, so you think that this pen, for example, has certain features and it doesn't have those features. So you think it, for example, writes with a certain color, or takes certain type of ink, but in reality it does not. That would go to the quality, not the existence of the subject matter. And as you can see on the left hand side, if the mistake is to the existence, then the contract is going to be void ab initio, or as in McRae, it still exists, and that would become a different matter in relation to what remedies you would get out of that. So on page 299, McRae was really about a contract to salvage an oil tanker. People thought, well, there was a commission, the Commission on Disposals Commission, the Commonwealth Disposals Commission thought that there is in fact this oil tanker, and they sent out a invitation to tender, and McRae actually submitted and successfully got a tender based on information provided by the Commission. Okay. Then it was found that never at any time was a tanker lying at or near the location given by the Commission. Okay. So the decision there was, by their advertisement to the public, the Commission impliedly promised that there was a tanker in existence. Okay. Leading McRae to believe that the tanker existed and in the location stated. On the strength of that promise, McRae had submitted a tender which had been accepted by the Commission. So then, because of that, there is a contract. A contract has thus been created, but which the Commission had broken by its failure to perform. So the Commission could not now avoid its responsibilities. Okay, so this was basically the issue. Of course, was if one of the parties makes an implied promise of the existence of subject matter and the other party acts and relies on that promise to their detriment, will the party making the promise be bound? And the court said yes. So the reason for McRae and the finding of a contract, although in reality really there is no contract because the subject matter doesn't exist, in this case the court said in fact yes, there is a contract to protect McRae, so that the Commission would not turn around and say in fact there is no contract because the subject matter doesn't exist. Okay. So then the comment, as you see on page 199, says McRae today might have chosen also to sue for the negligent misstatement of the Commission, okay, and or possibly under section 18 of the ACL. So those probably would be better venues rather than to have this fiction of saying that the contract exists. But for our purposes, it's one of the arguments that you could make in relation to a mistake as to the existence of subject matter. Of course, this was a common mistake in McRae because the Commission thought that the tanker existed at the location that was given, and McRae believed and thought that that tanker also exists and at the location that was given. Okay, as evidenced by their submission of a tender. So that was the common mistake in that case. Now you could also have these mistakes as to quality of the subject matter, as you can see on the right hand side, but if it's the quality, then you'll see that the contract exists. So the contract exists in common law but is voidable in equity. And the same thing in the case of Sole, and then the case of Bell confirms the same approach, that the contract will always exist if the mistake is to quality rather than subject matter. So you won't get really any remedy, but you might be able to get remedy not at common law but in equity, and you might find that the court at its own discretion finds that the contract is voidable. Alright. Let's then now move to mutual mistake, and the discussion starts on page 301, and you'll find that the mutual mistake refers to two different mistakes. Okay, so there are two parties and each one of them believes something different than the other. An example is given to you in the Ruffles case, and I'll leave that for you to read. And here you'll find that we apply the objective test of the reasonable person to ascertain whether there is an agreement. Okay. Now, if we find that there was no agreement, again the contract is void ab initio. Void ab initio. All right. Now, you will also find that there is something called unilateral mistakes, again on page 301. Here you'll see that one of the parties is aware of the mistake, so known or ought to have known to them, and does nothing to correct it. So it's for example, I'm selling you the pen, and I'm selling you the pen for $10. Now, I know that the pen does not exist, okay? But I represent to you that it exists, okay? Now you are under the mistaken belief that it exists, and I know that this is a mistake on your part, but I don't correct it, okay? You come to me saying, I want to buy this pen, I know it doesn't exist, but I don't tell you that doesn't exist. I keep that mistake in your mind, the unilateral mistake, that in fact this pen exists, and that makes it a unilateral mistake. It's a mistake on your part. I know that's a mistake, but I'm not correcting it for you. Okay? So you see that majority of such cases concerns fraud, and you'll find that it could also be mistakes as to the identity of the parties to the contract, or mistake as to the existence of content, i.e. terms of the contract. Now, if it's the one on the left hand side, which is mistakes as to the identity of the parties, then you'll find that no agreement and hence the contract is void ab initio. Okay? However, if parties meet face to face, there's a strong presumption. You remember our discussion of presumptions in chapter 11? There's a strong presumption that the contract exists but is voidable for fraudulent misrepresentation. If presumption rebutted, so you can actually prove that the presumption is wrong, the court could find contract void for mistake. Okay. Now there'll also be on the right hand side mistakes, as we said, as to the existence of content or terms. There is agreement and the contract exists, so the contract is voidable. If a mistaken party acted unconscionably, the contract could be voidable in equity. So it always goes back to this issue of whether there's agreement or no agreement. Okay, we are trying to ascertain whether the contract exists. That's the whole idea. And if it doesn't exist, it becomes void. So we made a mistake. In fact, the contract does not exist. So it takes us back to our first step in the analysis of whether a contract exists. Remember, there's the existence analysis, where we have to establish that there is agreement, intention to create a legally binding relationship, and consideration. And then we go to the next level, where we have the second layer of analysis, where we look at the validity of contracts. All right. We come then to non est factum, but before that, let me just run with you these 2 points. The first is on page 302, that talks about risk management alert. It says where parties meet face to face. So this is in relation to unilateral mistake. And an innocent third party is involved. So for example, someone steals, a swindler for example, steals something from you and presents to be someone else, and then they take something from you, like jewelry for example, and they go and resell that. When they resell that to someone who doesn't know that they actually committed fraud to, or commit fraud to obtain these goods, then they would be considered an innocent third party. So when an innocent third party is involved, the plaintiff must show that identity is crucial to completion of the contract, or the courts will treat the contract as voidable, thereby generally giving the third party title. Okay. Then there's also the business tip on page 3. Always take adequate steps to check the identity of any party with whom you are dealing. So you are business students, of course, and what we are telling you here is really commonsensical, but it's important to also put it in a formal way so that you remember what the consequences would be if you don't. Don't rely on what they say or who they say they are, or hand over any goods until you have taken all reasonable steps to identify the person with whom you are dealing. For the seller, this means getting the cash or a bank check before handing over the goods. For the buyer, it means making sure that you get title with the goods when you hand over the money. Okay? So I'll leave it to you to look at the cases shown or given to you on page 302 and 303, and we'll move to what we call non est factum. We are going to move to non est factum when we look at page 206, which says mistakes and written documents. This relates only to written documents. Notice that this is actually a defense. This is a defense that applies where there's a written document. So if the mistaken, so the signing party, the person who signed this contract, if the mistaken party succeeds in this defense, the court will declare the contract void. So how do you succeed? There are 2 elements. Okay, the first is that the mistake goes to the fundamental nature of the document that you signed and not its content, and that the absence of carelessness or negligence in the execution of the contract on your part. So what was signed was radically different from what the mistaken party thought they were signing, and you'll find an example of it on page 307 in Petlin and Cullen. Okay. Notice, however, as it says on the left hand side on the slide, not reading the contract does not prevent the defense where the mistaken party cannot read or cannot understand. Okay. So if unmistaken party's conduct exhibits fraud or undue influence, the contract may be voidable as well in equity. And that's what we will be discussing in the next part in our learning objectives 3 and 4. Okay, let's then move on to our second learning objective for today, that asks us to define and discuss different types of misrepresentation, their effect on a contract, and statutory intervention for remedies. So, representation, and you can go to page 348 for further discussion of that, can be either, so let's just start by saying that there's a statement. A statement could either have promises or it does not have promises. So it could have promises as to the truth of the statement, or it does not promise the truth of the statement. Okay, so this depends on the intention of the parties. If it's promises, if there are promises as to the truth of the statement, then it could either be a term of the contract, and there are types of terms, or it could be collateral contract, and we'll talk about this in some more detail when we get there. Okay, so we're saying that you have all of these details in the following. This is in chapter 14. In the following chapters, I will talk there about the terms of contract. But you could also have a statement that promises the truth of the statement, and it's not a term. In fact, it is a collateral contract. So these things we will cover in later chapters. And there are also statements that do not promise the truth of the statement, either through simple representation or through what's known as sales puff. Okay, so these are things that are pre-contractual, so before entering into the contract. This is just a bird's eye view of things that we will discuss in the following lectures, in the following chapters. Alright, so let's then look at representation. The statement, again, we said could be could promise the truth of the statement, or it does not promise the truth of the statement, and that's where we're going to go to talk about simple representation, which is what we want to talk about today. So a statement of fact intended to induce a party to make a contract. It's a statement of fact intended to induce a party to make a contract. Okay, but there are also sometimes other things like sales puff, or things like what they call statement of law, or state as to the future conduct, or statement as to the intention, and so on, including even silence or non-disclosure. Now these are not statements of fact, okay, and we will discuss these in later lectures, but remember for now that you will find them also caught under the Australian consumer law, and if you want to read about that right now, you can move on forward to pages 350 and 316 for discussion of that. Okay, so today we're talking about representation, and we're talking really in particular about misrepresentation, and you'll find that there are three different types of misrepresentation. A misrepresentation could be fraudulent, or innocent, or negligent. If it's fraudulent or innocent or negligent, the contract is voidable. Remember, we said at the very beginning of this lecture that under misrepresentation there is in fact an agreement. Okay, and because of that, we are not going to find that the contract does not exist, i.e. it is void. In fact, we'll find that it's voidable, and it's an equitable idea because it goes to fairness. So this has affected fairness basically to one of the parties, and the equitable thing to do would be to find that the contract is voidable at this injured party's election. All right. So you'll find that the remedies then under contract law if it's fraudulent, you can rescind the contract, and also you can get damages. So you can get compensation, monetary compensation. But there's also remedies under tort law, okay, where you could argue under the tort of deceit or under uh, uh, under the tort of deceit for damages. We haven't covered, of course, deceit, and we will do under Chapter 23 in later recordings. But if you are interested, you can move on to look at page 646 of Chapter 23, which is an online chapter. So it is available on the publishers, the Pearson website, Milo Lab. Then you have also under statute, so the ACL parts and the remedies under the parts that are given to you here in this slide. If it's innocent, then you can have remedies under contract law in terms of rescission and damages, as well as under statute, but not under tort law. And if it's negligent, you'll find that you'll still be able to find damage, or damages rather, under contract law and also in torts and under statute law. If it's innocent, okay, if the misrepresentation is innocent and it's a term, then you can find an example of that, i.e. a term of the contract. Then you could find an example of that on page 112 in Fitginton or Whitginton, and you'll find the other example where the innocent misrepresentation is not a term on page 150 under a case called Oscar Chess in relation to selling a car. Okay. So only remedy under equity would be rescission in that case. All right. Right. So let's then just clarify a bit more as well the difference between unilateral mistake and fraudulent misrepresentation. So if the plaintiff can establish a case for unilateral mistake, okay, where that mistake has been induced by misrepresentation, then unilateral mistake can get you the contract void ab initio. But if you argue that there was in fact rather a fraudulent misrepresentation, then the contract will only be voidable. Okay. Now if there are no third parties, it doesn't matter, the result is the same. The result is the same. Okay. However, if there are third parties, if you go under the unilateral mistake approach, then the third parties will not be able to collect anything because the contract was void, so there's no contract in the first place, and whenever they have received entitled to goods is not good title, and they would have to return the goods. Okay. If on the other hand there was fraudulent misrepresentation, then the contract is voidable. So you have to actually, as the plaintiff, you had to make sure that you go to court and make the contract voided before title passes to the third party. Before title passes to the third party. There's more discussion of this point on page 301 and 308. So the key point is that if there are third parties involved, you have to make sure that if you go and argue fraudulent misrepresentation, that you have to act quickly. You have to act quickly. If you don't actually bring the matter to the court's attention and get the judgment that the contract is voided before the person that actually carried out this fraudulent misrepresentation, and by doing so has taken some goods from you, for example, before that person sells these goods onwards and converts them into cash. Because once they do so, and the person that they have sold these goods to is in fact an innocent third party, i.e. they did not know that these goods were obtained through fraudulent means, then that innocent third party would still hold a good title to those goods because you did not make the contract voided before they got their title, before they received the goods from that person that carried out the fraudulent misrepresentation that through which they got the goods from you, and then they sold them onwards to this innocent third party. Alright, let's then move on and finish off on the third and fourth learning objectives at the same time. It says, the third one says, explain the doctrine of duress and undue influence and describe their effect to avoid liability on a contract. And the next one says, describe unconscionable conduct, its common law remedies, and effects of statutory modifications to the common law. Now, this slide here gives you a bird's eye view of the discussions in your textbook. So there are three different things we need to look at: duress, unconscionable conduct, and undue influence. And not to our surprise, by now we know that the contracts under these issues, when these issues arise, the contracts are only voidable, because this is all really the jurisdiction of equity, and we're really looking at situations where there is an agreement but there is an issue with that agreement. So contracts are voidable, and you have the examples there where you have duress, for example, to the person or to goods, or economic duress. And the discussion starts on page 316, where they define duress. It says there, duress is the use of violence or illegal threats against a person, their goods, or their economic interests, to force them to enter into a contract against their will. Okay. And then you have unconscionable conduct, and that starts on page 321. And again, it talks about a general rule at common law that the courts will not interfere with a contract that appears to be the result of unconscionable conduct by one of the parties. However, in its equitable jurisdiction, the court will set aside the contract as unconscionable where there has been an abuse by the defendant, or there has been abuse by the defendant of their superior bargaining position in their dealings with the plaintiff. Okay, and you'll find that there are examples of unconscionable conduct on page 321, and it says that in the in brief box on page 322, what has to be established for a contract to be set aside as unconscionable, and talks about for a contract to be set aside on the grounds that it is unconscionable, the plaintiff must prove four things: they were in a position of special disadvantage, it must have substantially affected their ability to protect themselves, the defendant must have known or should have known of the plaintiff's disability and had taken advantage of it, and that the actions of the defendant were unconscionable, i.e. unfair or unjust. Then you'll also find statutory modifications discussion as you see on page 323 and as summarized in this slide. The last thing I want to talk about today is unconscionable influence, and unconscionable influence starts on page 319, and there you'll find that it says undue influence. So we're talking about undue influence. It says undue influence involves the improper use of a position of influence or power possessed by one person over another in order to induce the latter to act for the former's benefit. And you'll find the in brief box on page 319 gives you the types of undue influence, where there is no special relationship or where there is special relationship, and the onus on whom so if there's no special relationship, it says there is onus on the plaintiff to prove that the defendant exercised this influence, and the onus switches to the defendant under a special relationship. So there it is actually the onus on the defendant to prove that the transaction was voluntary and that the plaintiff understood the contract. Alright. Then there's the last thing we have to look at really is what's known as unfair contract terms, and that comes up on page 324 at the end of the chapter. It says in addition to the unconscionable provisions in the ACL also addresses the use of unfair contract terms in consumer contracts. So that's what we will really talk more about in chapter 14. It is limited in its operation to contracts for the supply of goods or services, or a sale or grant of an interest in land, and to an individual for personal, domestic, or household use or consumption. Under the ACL, the courts have the power to permit a contract to continue to operate without the term, and it will continue to bind the parties. So you will sever the contract, sever the term rather from the contract, and let the rest of the contract operate. For the contract to be void, the term must be unfair, and the contract must be a standard form contract. Okay. All right. So that's then the end of our lecture for today. We'll leave it there, and the next time we're going to look at the next step of our validity of contract analytical structure, namely the idea of the legality of the object or the whether the contract is a legal contract. So basically legality or illegality of the contract, which is going to be our discussion in chapter 13. Thank you for listening and watching, and I'll be talking to you again soon.